When the Indian Constitution was written, the Supreme Court was decided to be the final arbiter of the Indian Constitution, hence, often termed as the world's most powerful court. It was given special powers. One of the key powers is under Article 142. Think of it like an emergency button. If a situation came up where the usual laws couldn't fix things and strict procedures stood in the way of justice, the Supreme Court could step in to make sure justice was done. This power, which was meant to be rare, is being used more often. And now, the debate is ripe whether the judiciary is stepping into areas that belong to elected leaders and executive authorities, or whether the judiciary has been forced to step in and end a decision paralysis. So what exactly is Article 142? It allows the Supreme Court to pass any order necessary to deliver complete justice in any case before it. Let's take a recent example. In 2024, the Tamil Nadu government passed 11 bills. The governor, who is appointed by the president, refused or delayed approving them. Under Article 200 of the Constitution, the governor can send such bills to the president for consideration. The Supreme Court took a bold move to clear the passage of the bills, citing public welfare concerns and accepting the argument of the state government that the elected government was unable to implement its schemes. There have been precedents before, like in Maharashtra government formation case in 2019, where the Supreme Court ordered a floor test within 24 hours, or in the Rajiv Gandhi assassination case, where the court used Article 142 to release convicts after years of delay by the executives in deciding mercy petitions. These weren't direct confrontations with governors, but the court stepped in to end decision paralysis. Now, let's connect this to issue of judicial appointments. After the Supreme Court scrapped the National Judicial Appointments Commission in 2015, it brought back the collegium system. When the centre delayed appointments, the court hinted it might use Article 142 to push them through as the last resort. When examining broader implications of recent developments, it is important to consider how this trend may impact the constitutional balance in India. Frequent recourse to Article 142 can shift the Supreme Court's position from an impartial arbiter to an active participant in governance. The situation can arise, particularly when political opportunism and populist moves by the government compel the court to navigate complex and ambiguous issues. Such dynamics can pose challenges in a democratic system where power is meant to be distributed among the parliament, the president, the states, and the judiciary. In conclusion, when the Article 142 was intended to serve as a measure of last resort, its frequent application in institutional conflicts risks undermining its exceptional nature.